Record. On record in State v. Davis, C-377-407. For the record, Mr. Davis has waived his appearance for this hearing previously. What document are we working off of, Mr. DiGiacomo?
The one I just sent you.
Okay.
We negotiated some language in a bunch of the instructions.
Okay.
The issue still before the court, and I sent you got the defense instructions earlier.
Yes.
Is one, whether or not we give a voluntariness, and if we give a voluntariness of the statement, what voluntariness of the statement instruction should be given.
Okay.
Two, we have a dispute over what corpus delicti rule instruction we give.
Of course.
The defense has withdrawn their 51069 request. The attacking the hearsay as if he testified to the client, as if he testified, they've withdrawn that.
Okay.
And then the defense does not want self-defense instructions, but the state believes we're entitled to them since Mr. Davis claims self-defense in at least one of his statements.
Okay.
Good morning, Your Honor. Attorney Talene Pandak, bar number 5734 on behalf of the defense.
Okay.
I did print a copy of our initial defense proposed instructions. Would you like a printed copy for now?
I have an email copy. If you want those filed, go ahead and.
Well,
as proposed.
we are withdrawing one of the instructions.
Okay.
On page 9. On page 6, we're withdrawing the hearsay instruction. Pages 7, 8, and 9, the state has agreed to modify those and use our proposed exhibit.
Okay.
So you are here to determine if the defendant is guilty or not guilty based on the evidence in this case as opposed to guilt or innocence.
Okay.
And then the state also changed the one about the subject of punishment to not say guilt or innocence,
Sure.
but to talk about the burden of proof. The state has also agreed to give the instruction on page 9 of our proposed instructions on the constitutional right of a defendant not to testify.
All right. So then what I think makes the most sense, tell me if I'm wrong, is just to go through individually. When there's no objection, just number that, move on to the next one, and organically raise the issues as they come up with the instructions. If there's something that doesn't get raised, ultimately by the end, then I'll circle back and ask about the defense proposed.
I would agree with that, except for I don't think you want to number, if you do wind up giving the voluntariness, I don't think you want to number them after the last instruction. So
you want to start with
maybe we should address
voluntariness?
whether or not we should be giving voluntariness, and then when we get to the area where you want to argue voluntariness.
All right. Let's go voluntariness of statement as our first issue. Let me pull up the instruction that you have proposed. Defense. And then state has presented an alternate.
An alternate, but also an argument that there is no voluntariness that gets submitted to the jury.
Okay. So is the instruction that you are proposing to give the one from Vasquez-Reyes versus State and Colorado versus Connolly, Ms. Benedict?
Oh, I am.
That's the one that the state is proposing.
My proposed is from Carlson versus State, 84 Nevada 534.
If you actually just want to approach with yours, at this point, I don't know. It doesn't look like I received your entire packet, so everything. So I can just go through it printed. Thank you. All right. So the instruction that the defense is proposing three different instructions, correct?
I have 3 different options. The first one is directly from Carlson versus State. The second 2 are from instructions that I used as a district attorney.
All right. So what's your preferred one that I start with?
I'm happy with all 3 of them.
Okay, so you'll take any of the first 3. So either
And definitely the second one on page 3 talks about the difference between an admission or a confession, so that one's different from the page 4 one, which talks about the totality of the circumstances and the voluntariness.
State, what's your objection regarding a voluntariness instruction being given at all?
In both the cases cited by the defense, and I recognize, both of them say where voluntariness of a statement is an issue, that you have to submit it to the jury. The mere fact that they filed a motion to suppress on voluntariness doesn't create an issue. They have presented, you have to, as Connolly says and Vasquez-Diaz says, you have to establish some improper police coercion, and they have not done that in this case. The audio of the statements do not reflect any improper police coercion. Both of those, neither one of those, have you found to be to be custodial, and so in both these cases, they're Mirandized statements of defendants who are in custody. There is a lot of law that, right, you know, if there's evidence of self-defense, you got to give self-defense. If there's evidence of a voluntariness, you have to give a voluntariness, voluntary manslaughter. There is zero evidence before this jury that they could factually make any sort of determination as to the voluntariness of the defendant's statements. By its very definition, a proffer cannot be involuntary because it is a negotiated contract between two people. So the only statement this could apply to would be the 2009 statement, and when you listen to the 2009 statement, it's clear there's not a single improper coercive conduct by Detective Long. Now, had the defendant got on the stand and said, hey, they beat me with rubber hoses before I went in the room, or hey, the cops told me this, or the cops told me that, or the cops told me this. The evidence before this jury is he was caught with PCP and a gallon of PCP and a kilo of cocaine. They told me I could be prosecuted for that, or I could give a statement. I negotiated a contract with my lawyer, with the government, to go in and give them a statement. By its very definition, it cannot be involuntary. And so, if you instruct a jury on this, particularly the instructions they're requesting, it would be highly, highly confusing to the jury, and it's not an issue in the trial, because they've brought zero evidence of coercion, improper police coercion, into this case. And because of that, I would say they're not entitled to a voluntariness instruction.
In reviewing the instructions that are proffered, Ms. Pendick,
Can I approach to give you the two cases, Carlson and Morrison?
you may. My initial concern in reviewing what you have stated before I even get to the threshold matter of whether you've met, well, first I'd have to decide the threshold matter, but if we were to give an instruction, all instructions say that ultimately if a jury concludes that a confession or admission was not made voluntarily, then it's up to the jury to determine whether they should consider it. However, none of the three instructions give any insight to the jury as to how they would determine voluntariness. As a judge, when there's this motion to suppress brought up before me, in general, I have factors to consider. The jury would have none of those in the proposed instructions, and so it would be giving them a task that they have no way of accomplishing, essentially, is what is in front of me.
And what the defense is submitting in the Carlson case, they had an instruction that the Nevada Supreme Court ruled was sufficient in that case, and that is in the state's first proposed exhibit. And they actually gave the footnoted instruction of the fact that the court has admitted into evidence the alleged confession or admission of a defendant does not bind the jury to accept the court's conclusion, and the jury, before it may take a confession or admission into consideration, must for itself find whether or not it was voluntary confession or admission. If the jury concludes that a confession or admission was not made voluntarily, it is the duty of the jury to entirely disregard the same and not consider it for any purpose. That is directly from the Carlson case.
They're saying voluntary carries a clear meaning without need for further definition or explanation.
That was going to be my very next argument, Your Honor. And they did say that it was error if the court did not give that instruction. And what they talked about was, and this is going to be something that's a theme running through all of our objections, there is a difference between admissibility and the question of fact that the jury now needs to decide. So here, Mr. DiGiacomo is absolutely correct that you have the initial determination of admissibility. You have ruled that it was voluntary. This will be an issue on appeal. This will be something that will be brought up by the defense should Mr. Davis get convicted. However, you also then are required by the Nevada Supreme Court to instruct the jury based upon their role now, which is determining whether or not there is evidence beyond a reasonable doubt. To me, that is how I read these Nevada Supreme Court cases, that you need to give these instructions. I do see the court and Mr. DiGiacomo's concerns. It is the defense position that we'd rather have all of the instructions given as opposed to just the state's. So I think it's better to instruct the jury than to not about all of the applicable rules. But I do think, and this will become even more important in the next argument about corpus delicti, I think that we do not need to instruct the jury on questions of admissibility. I do not want them to be confused about the proper standard that they need to decide, which is proof beyond a reasonable doubt. At this stage, it's a question of fact for the jury.
So let's work backwards then. Where in this record do we have evidence of improper police coercion, where we don't have, we have a statement that was given in the presence of police, or in the presence of his attorney that he brought there. We don't have any of the typical PASAMA factors present of, you know, someone who's very young, someone who's very hungry, someone who's very tired, someone who's very susceptible to police coercion because of their lack of familiarity with the criminal justice system. We have none of those factors present here. Additionally, we have a defendant.
Would disagree.
But hang on a minute, and we also have someone who has not testified to explain a circumstance outside of those. Outside of what is actually within the videos, and then ultimately no evidence that well, apparently it would be difficult to know what to apply to this situation, but what is the, I guess, improper police coercion here?
Well, the defense, we all should not be arguing this right now. It's a question of fact for the jury. I'm not going to restate the evidence that we already heard at the trial because it's up to the jury to decide.
You need to make a prima facie case.
Exactly, but it is our position that those factors, whether they've been met or not, would be up to the jury to determine. Both sides are going to have arguments and closing arguments that are going to be very different. This is one of the biggest issues in this case, and I think it's important to continue on to allow these instructions to be given as decided by the Supreme Court. I think it would be error not to give the instructions, and I think that there is some evidence of psychological pressure. That is going to be something that the defense may argue in this case based on the testimony at trial, but I don't think it's appropriate for us because it's a question of fact for the jury.
But we need to get at least that there's something in the record to show, you know, like if we're talking about voluntary manslaughter, you have to have at least that scintilla of evidence to get over that very small molehill. What evidence is there to give these voluntariness instructions at all to get that first hurdle that Mr. DiGiacomo is, I guess, complaining about?
And I know that this court disagreed with the defense when it filed its motion to suppress the statements, but the defense detailed at length what the promises were. There were explicit promises made to the defendant in the 2008 proffer. There were implicit promises not to use it against him in the second 2009 interview, and those promises, while contested by the state and contested by the court, there was evidence of promises made to the defendant. There was evidence about confidentiality that they agreed to keep. There was evidence about when that confidentiality was broken, who broke it first. These are all issues that are going to come up during closing arguments, and I'm sure they're going to be issues that are going to be deliberated by this jury in making a decision.
But none of that goes to voluntariness. Somebody violating something 5 years or 3 years afterwards doesn't change the voluntary nature of the statement. The person or the entities that contracted have never violated the agreement that was contracted. The contract was between Mr. Higgins and the U.S. government. The U.S. government never violated the contract. The suggestion that as a matter of law, you can never have an involuntary proffer. There would have to be some additional information that is elicited. The fact that they don't like what Mr. Kading did does not somehow change the nature of what happened 3 years before. And so the psychological pressures that they're talking about are exactly what Colorado v. Connolly say are not appropriate for purposes of the Sixth Amendment involuntariness. That is clearly not a situation where they're allowed to argue to a jury that because him and his family were wrapped up in a drug deal, that he somehow has the right to claim that his statements are involuntary. The Sixth Amendment is there to protect against improper police conduct. It is not there for this purpose. So when they use the term voluntary, he didn't have a choice. Well, he did have a choice. He could go to prison for the rest of his life on drugs. But he chose to make a statement to the police. And so there is no evidence of anything improper police conduct that has occurred here.
May I add something, Your Honor?
You may.
I wanted to clarify that the burden of proof is on the state to prove by a preponderance of the evidence that the confessions were voluntary. That is a burden of proof at the time of trial, not at the time of the motions. So in this case, they do have that burden to prove that beyond a preponderance of the evidence. So I think that's also relevant, and I think it's important in this case that we give this question to the jury based on the Supreme Court law that's in place. But as Your Honor well knows from all of the briefing in this case, there is very little law specifically on point to this issue. This is a unique issue. This is something that could create new law in the state of Nevada because there's very little law in Nevada that even remotely talks about the situation that we have in this case. And I think that it's very important to protect the record that the instructions be given. And I'll submit it to Your Honor.
Okay. I think it's safest to give some sort of voluntariness instruction to this jury. Given the precedent in the Nevada Supreme Court, given the Carlson versus State case, I definitely agree with a lot of the state's arguments, and that's why I ruled the way that I did initially. However, it's clear that this has been an issue that has been raised by defense. It's something that they disagree with my ruling with pretty strenuously. And in the record, there is, that statement by Detective Kading in that 2008 interview that this will never be used or this will never be heard, which was the basis for that voluntariness. I still think that wasn't the correct framework, but I think giving it ultimately to the jury is maybe a way to hedge our bets. So, that being said,
and I'd ask you
let's talk about the various instructions and how we're going to do this.
I would ask the court, and I will tell the court that, I cannot believe I'm actually going to say this, but I pulled those instructions on voluntariness from the Nevada pattern jury instructions. The only thing I did was conform slightly to this case and added to Colorado v. Connolly portion that says self-interest or an expectation of receiving a benefit does not make a statement involuntary. That isn't actually in the pattern instructions, but clearly it's the law, and that's why I sent you Vasquez Reyes, because Nevada has adopted Colorado v. Connolly. And so the instructions I gave you on voluntariness, and I'm trying to pull them up here because I didn't have them up on my computer initially here.
And so these are, your instruction is the pattern?
Is the pattern with the exception of the last line on the first page,
Okay.
I believe.
And so, Ms. Pondick, the instructions that you've given me, obviously the one on page 2 involves Carlson and Lorson.
Yes.
Those are Nevada Supreme Court cases. The other two sites are simply to the stock CCDA brief bank instruction. Do you know where those necessarily come from, and if they were not incorporated into ultimately kind of the pattern? The idea was to incorporate those stocks into the patterns.
Those have been instructions that have historically been used by the district attorney's office that have been upheld by the Supreme Court. So those have not been challenged. Those haven't been, there have been no problems associated with those instructions. That was initially what I had asked the state to include that precipitated all of this.
Okay.
So I wanted to make sure that the court had those instructions. I agree with the state that their instructions are a correct statement of part of the law that applies. I'm not saying it's complete in terms of all the issues in this case, but as to the PASAMA factors, those are the factors, and I do agree that they're correct statements of the law. So we do not object to the admission of all the instructions, both the state's proposed as well as the defense proposed.
Well, the second two DA brief bank, I'll be honest with you, and she was at appellate for a long time. Those are no longer in our stock instructions. These pattern instructions of what we've put into our stock instructions, because those are clearly, as the court noted, not adequate to explain to the jury voluntariness in a legal sense what that is. And so if you're going to give the instructions, I would urge you to give the Nevada pattern instructions with the Connolly addition to them. But not, well, I mean, I think it's superfluous to even have the what is it, the Carlson-Larson one, because these fully explain, these two instructions fully explain, hey, there's a confession and an admission, here's what the difference between the two are, here are the factors to consider in determining voluntariness, there needs to be improper police coercion involved in them.
I don't believe those two are sufficient. And I think that under Carlson, them saying that the term voluntary contains a clear meaning without need for further definition or explanation, that's also a clear mandate by the Supreme Court. But I would ask at a minimum.
Mandate from 1968.
Right. But there's been nothing.
In which the defense was
new.
actually asking to give the factors to the jury, and the court said it was sufficient in 1968. But this is a very specific voluntary issue, right?
Okay. Turning back to Ms. Pondick, when I look at the instruction the state is offering, it does seem to incorporate what you've included for 3. It talks about what an admission is, what a confession is, and what the definitions are. It seems to be very similar language, and I think it was probably what was used to make the stock pattern, the stock instructions that the Supreme Court is encouraging us to use.
Yes.
And so it seems to be the predecessor to that. Would you agree with that?
Yes, it is fine to use both of those instructions.
Well, I'm just saying, I don't know that we need instruction 3 if that one is being given.
That's fine, Your Honor.
Okay?
I just want to make a complete record.
No, I understand. I'm just, if you agree with me that it's already incorporated in the instruction, I'm not going to give duplicates.
Okay.
So
Exactly.
3 doesn't seem to make sense. Page 3 doesn't seem to make sense. Page 4, let me compare that. I think page 4 does include additional factors, which include that the state has the burden of proving voluntariness by preponderance, but then it goes into the voluntariness being a question of fact to be determined by the and what you're to do if it is determined to be involuntary.
And I would ask that that instruction be given.
So I think 4 is incorporating your instruction 2. It has all the same features. So my thought is to give the state's instruction as well as page 4. And I'll let Mr. DiGiacomo be heard on that, just because it will avoid duplication of the exact same issues that could confuse the jury. Additionally, it includes an explanation to the jury of what to do to determine if it's when you determine it's voluntary or involuntary and who has the burden.
Okay, so you're going to give both of the states, and then you're going to add 4?
Oh, the state has a second?
The second
I
one.
haven't gotten to the second.
Yeah, the second one actually has all the factors listed out, and it does cover everything that's in her number 4.
Okay. Let me look at that one. I apologize.
Which one are you on? Page 2?
Page 2 of ours, the passive factors.
The state, and it includes that the state has the burden of proving, which I indicated earlier was a very important part of instruction 4. I think ultimately in comparing page 2, it does encompass all of the ideas of page 4.
So instruction number 2 will not be given on page 2.
Right. I think what she's saying is she's going to take R2, it encompasses all 3 of yours. Is that what you're saying?
No, she's going to give on page 4.
Well, I didn't realize there was a page 2 to the state. What does the state's proposed either omit? I see that it adds the PASAMA factors, and you guys don't want the PASAMA factors given. Is that sort of the difference there?
I already said it was fine to give all 5 instructions, so I'm not saying that their proposed instructions are an inaccurate statement of the law.
Got it. Understood. So at this point, I'm going to give voluntariness instructions over the state's objection. However, I'm going to use the 2 that the state has proposed because they are pattern instructions, which we are encouraged to use. Additionally, in reviewing them and comparing them to the ones that were sent over by the state or by the defense, they do include all of the factors, as well as the fact that the state has the burden of proving the voluntariness by preponderance of the evidence. So I think they encompass everything that is necessary. They encompass the defenses, and to avoid confusion, I'm not going to give all 5. I'm just going to give the 2 that include the same ideas.
What about the one on page 4? You had said earlier you were going to give that one.
And I think that was before I knew that the state had given me even a second page.
Oh, okay.
So I was just looking at page
Okay.
1. I apologize. So now that I've got that. All right. So the voluntariness instructions will be given as proposed by the state. But to be clear, the state does not want voluntariness instructions. The other issue that we needed to address was corpus delicti. The defense is proposing on page 5.
And to be clear, Your Honor, the defense objects to the corpus delicti instruction proposed by the state. The only reason that we provided an alternative proposed instruction is because they included it in their packet. The defense objects to any corpus delicti instruction being given to this jury at all for these reasons. While the first attorney in this case had potentially raised a corpus delicti issue in his motion to dismiss, this defense team has not raised corpus delicti either in a motion or in front of this jury. That issue has not come up. It is a question of admissibility, not a question as to weight, and the defense objects to this instruction being given because we believe that it is confusing and misleading to the jury because their duty is beyond a reasonable doubt, and their duty is as to weight, and it's confusing to even have this instruction. However, if the court disagrees with the defense position and will give an instruction, the case provided by the state, Sefton, that's actually from 1956, and the proper standard is the Doyle case. In the Doyle case, they provided, this is the exact instruction that comes out of Doyle, which is Doyle versus State, 112 Nevada 879 from 1996, Nevada Supreme Court, and that instruction is a more accurate statement of the law.
Your Honor, may I be heard?
Which one is your corpus instruction?
That is on page 5.
No, sorry, states. I'm on yours.
Okay.
It's near the end. Oh.
Give me the first couple words once you find it so I can...
Where independent evidence.
Where independent evidence. Okay, then I can control that then.
It's about 42 of 53. Although I may have I just added in the voluntary instruction, so maybe not.
So the instruction the state is proffering reads, where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I don't know that that's necessarily a corpus issue.
It is, Your Honor. So this is what, and I'm going to disagree with Ms. Panduck with regards to the defendant's the never taking the position that about the corpus delicti issue. What Mr. Saft told the jury in his opening statement is, you have to corroborate what the defendant says. That is not the law. So the question is, when we talk about what's clarity to the jury, what is the law? The law is we have to prove when a person gives a confession, absent their confession, we have to prove, one, that a person is killed, two, by the criminal agency of another. But what Sefton says, and what even Ms. Panduck's case says, and I'll get to why that's not applicable here, but what even Ms. Panduck's case says is that once you've established there's a crime occurred, you don't have to corroborate any other aspect of a defendant's statement. Now, of course, they can give it to whatever weight they want. But
Isn't that the inverse, though, of what a corpus argument would be? Is that there is only a statement and nothing to back it up.
Yeah.
You're kind of inverting it.
No, this came up specifically in Sefton. In Sefton, specifically what happened was there was a dead body, the person confessed to the crime, and what the defendant argued is, well, you never independently corroborated my other statements connecting me to the crime, therefore it's a corpus issue. And what the Nevada Supreme Court held is that there's not a third prong to corroboration. There's one, death, two, by criminal agency, three, what the defense had proposed, and what Mr. Saft has proposed to this jury specifically is that the third thing you have to do is corroborate that a defendant's statements connecting himself to that crime are true. And I don't think there's any credible argument to say that that's not what Mr. Saft said. I mean, it's a direct quote from his opening statement. But that's not the state of the law. And what Mr. Saft makes a argument that is an inaccurate aspect of the law, increasing our burden, we are entitled to an accurate statement of the law. And what an accurate statement of the law is that we do not have to corroborate anything beyond the corpus delicti. That is the corpus delicti rule, is that we don't have to corroborate anything beyond that. And so, the question for this court is Mr. Saft, because he's certainly going to say it during his closing argument, and he said in the opening statement, is Mr. Saft allowed to give a false impression about the law to the jury? And the question of that should absolutely be no. Because in the absence of anything, with the absence of an instruction telling them that that the corpus delicti rule is that we don't have to, and even if you don't want to call it the corpus delicti rule, the rule is, regarding confessions, is that we do not have to corroborate anything beyond person being killed and the criminal agency. And so Ms. Panduck, again, in Doyle v. State, the thing that she pulls is from a kidnapping case. from a kidnapping charge. But in another case that Ms. Panduk cites, West v. State, gives a very similar understanding of
You
the...
actually cite West v. State too.
Yes, well, she cited it, we cited it, we both cited it.
Yeah.
And the one thing that we can agree is the two parts of corpus delicti, the only thing that we have to independently establish is the death and by criminal agency. That's the only thing we have to establish. We don't have to corroborate anything else. And so the only question is the jury going to have to be, is the jury going to be misled about whether we have to corroborate or not? And what the instructions are there to do is to have them not misled as to what our burden is.
May the defense respond.
1 second, I'm not quite through with understanding the state's argument. Sefton states that you need, for a homicide, you need proof of corpus delicti, which we've always had in this case, right? No one ever...
Never challenge that. Well,
there,
not during the trial.
there have been challenges to in the media as to whether Mr. Shakur is alive or dead, but in general, we've always had the fact that Mr. Shakur died that day, and the body of the crime has always existed. And so corpus delicti wasn't really the issue here. It was the defendant's corroborating confession. Is that enough? And so...
Okay, so we can...
So I think that's...
So if you want to get rid of the first sentence where independent evidence established that the victim's death was caused by criminal agency another, that's fine. But a defendant's own statements admitting the crime need not be further corroborated as an accurate statement of law. And if I may read from Sefton v. State,
okay.
It does say, a conviction based on confession will stand, although it is uncorroborated otherwise by proof of corpus delicti. So what Sefton specifically says is, we do not need to corroborate a defendant's statement. What Mr. Saft told the jury is we need to corroborate a defendant's statement. So the question before this court is simply whether the jury gets the accurate state of the law or they do not.
You may respond.
Thank you.
Ms. Panduk.
Yes.
What the state argues is actually incorrect. The issue is regarding admissibility. So this instruction is only relevant for admissibility. If there was no corpus delicti, then none of the defendant's confessions could even be admitted at all. You would have been precluded from admitting them to even let the jury hear about them. What the defense's concern is now is that this is improperly impeding upon their duty to find guilt beyond a reasonable doubt. This is infringing upon that standard. There is absolutely no law that talks about the fact that you do not have to corroborate a defendant's confession in terms of a jury verdict with beyond a reasonable doubt as a standard. And I would like to use the example, there is one situation, that is the Gaxiola case, and the Gaxiola case, I believe, oh, here it is, I have the site. 121 Nevada 638 from 2005. The testimony of a victim of sexual assault does not need to be corroborated, and that is entirely different than the situation in this case. The confessions were admitted into evidence. That was correct. They absolutely can be admitted into evidence, but this instruction improperly instructs the jury that there's arguments by the state, arguments by the defense, that they get to consider. They get to consider all of the evidence, and we cannot interfere with the burden of proof. So the state is wrong.
So, Your Honor, if I may be heard, like Sefton is not about admissibility. Sefton doesn't say this is about admissibility. It is about the threshold of proof, which is here. Now, if the court wants to add, it's still up to the jury to determine what weight to give to a statement. That's fine. But in terms of like the inaccurate statement of law being offered
Where
to the jury,
in Sefton does it say a defendant's own statements admitting the crime need not be further corroborated by evidence connecting the defendant to that crime?
okay, it's if you do a Control F cert, F5 if you want, if you're there.
Sure.
It says use conviction based on a confession will stand, although it is uncorroborated otherwise than by proof of the corpus delicti.
It doesn't cite to any other cases.
Actually, it does. In footnote 41, it goes on to say, it says, to this text, many authorities in support of this rule, and where corroborated evidence has been adduced, the rule is further stated. The corroborating evidence need not be such as to connect the accused with the crime. And then it goes on to say, hundreds of cases supports this rule and are cited in this note.
I believe Doyle supersedes that.
All right, let's look at Doyle.
And again, Doyle is
a kidnapping case.
Doyle is, they're talking about specifically a kidnapping case. Or kidnapping charge. It's a murder case, but a kidnapping charge is where the corpus comes in.
I don't think that matters.
Instructing a Gaxiola, but not instructing this case.
The West case that you guys both agree on, let's talk about that maybe.
Okay, well,
So that is clearly, that's a no-body homicide, correct? Brookie West, right? That's
Yes,
what you're
there was
citing?
no body in that
Okay.
case.
So obviously a very different situation.
yeah, that's just the two precedent factors that the state has to independently prove, which is the fact of death and the death occurred by the agency of another.
And I don't want to jump in, but she mentioned Gaxiola. Why would we be entitled to instruct a jury that a victim's sex assault cannot be corroborated, but we can't instruct that in a defendant's statement? Gaxiola supports the argument.
And this isn't an attempt to change the burden. If the court wants to add to this that the state still needs to prove the case beyond a reasonable doubt, or it's up to the jury to give what weight it wants to give to the statements, that's fine too. But it is axiomatic that we do not have to corroborate a confession. And the law supports that position. And Mr. Samt has told the jury different, which is not true.
We need the proof of corpus. So really the argument here boils down to whether the defendant's statements need to be corroborated by any evidence, or in the case of the Ms. Panduct is stating it needs to be slight or prima facie for the kidnapping.
Well, that is regarding whether the crime occurred. That's not even about whether or not his the statement.
Right, okay, because when in the kidnapping context, there's a situation where that crime could have not occurred.
Right.
There could have been no kidnapping whatsoever. It could have been a complete fallacy, a complete made-up situation. Whereas when we're talking about a homicide, there is proof of corpus automatic within the body existing.
Correct.
Okay.
Doyle is just not used in kidnapping cases. That's the standard that's been used since it came out. Everyone cites to Doyle. Doyle is the standard for the corpus delicti rule.
Not according to West, which says the corpus delicti rule in Nevada is well established. To prove that a murder has been committed, the state must demonstrate the fact of death and the death occurred in a criminal agency of another. So that's what we got to establish. And then independently. And then the only question is, do we have to corroborate anything else or not? And the law is clear. We don't have to corroborate anything else. Now, of course, and Ms. Panduct does have a fair point. They're not required to accept it. But we're also not required to corroborate it. And that's the impression that the jury was given by Mr. Sanf when he said, you are required to corroborate it. We know that's not the law.
A defendant's statements essentially, if believed, kind of borrowing that phrase from Gaxiola.
Okay, yes. If believed, that is fine. I think that's fair. They don't have to believe it. I'm not trying to communicate that. I'm saying they don't have to believe it, but they don't have to corroborate it.
The defense still believes that also in West, it says corpus delicti must be established before evidence of a confession or admission may be considered to prove that the accused was the criminal agency that caused the victim's death.
Yes.
So the defense maintains this is a question of admissibility, not a question of fact for the jury. It doesn't apply and
You
should not be
just
given.
stated that in order to get into the statement, you have to show that a crime has been committed. And the state did that because we have a body. That's literally the corpus. So a corpus is beyond approved, right?
Correct.
So
We didn't raise.
Brookie West is totally different because Brookie West, there's no body. And so how do we know that it's a crime? Those are all the issues. Here we have a body, always had a body.
I know, but I don't think the instruction should be given because it was not an issue in this trial. You
Corroboration.
admitted the confessions. This would be an issue to keep the confessions out of the jury's hearing. But here, they got to hear all the confessions. So now we're infringing upon the right of counsel to argue their case in front of the jury and the right of the jury to make the decision, the duty of the jury to make their decision beyond a reasonable doubt. This instruction should not be given at all.
All right, so
I'm sorry.
you might want to just listen for a second, Mr. Paul. Okay, so the state's instruction, I believe, is in reading through and reconciling it with Septon versus State, as well as the reiteration in the Brookie West case, is a correct statement of the law. However, I think the arguments of defense and everyone has been that these statements are not to be believed. And so I think the if believed language borrowed from Gaxiola adds that component in. So what I'm going to do on this instruction is say where independent evidence establishes the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime.
Your Honor, so you're going off of the state's?
Correct.
Can you do it a little bit slower, please?
Absolutely. I'm going to send you guys a copy of everything, but where independent evidence establishes that the victim's death was caused by the criminal agency of another, and just paraphrasing, that is directly from West, a defendant's own statements, if believed, admitting the crime, need not be further corroborated by evidence connecting the defendant to that crime.
Are you going to add any of this defense proposed exhibit, the defense proposed instruction?
So, the defense. Well, the defense proposed instruction says there needs to be slight corroborating evidence independent of any confession or admission, but that ultimately goes to the crime, to whether corpus is established. So the first paragraph is, or the first line is literally saying where corpus is established, but explaining what corpus is. So I don't think that there's any way, given the court's ruling, to include that a slight or prima facie showing permitting the reasonable inference that a crime was committed is sufficient, because that would be impeding essentially on the corpus determination, which we've all agreed in this case is established. There need not be. And additionally, the final line of what this defense has proposed does say there need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confession or admissions. Is that something that you're seeking to have added, Ms. Panduct?
I moved to have the entire
okay.
instruction, and I would ask that any part of it still be given because I believe it is more informative and less confusing and misleading than the instruction that the state is proposing.
Okay. Any objection to the final line being added?
Yeah, I think it actually confuses the instruction as currently given. There need not be independent support for each fact contained in the confession or admissions in order for the crime to be proven independently of defendant's confessions or admission. To me, is less clear than defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. I think our language is far clearer for the jury, and I think this is more duplicative than anything else.
I also believe that there should be a reasonable doubt admonition then as well placed in here. I believe this is still confusing to the jury, and the defense should be able to do the arguments as they intended.
What's the proposal to add a reasonable doubt instruction into this instruction? Or is that something that you
I would
believe
ask,
could be fixed by putting it close to the reasonable? Well, what are you asking?
no, I would ask that in this instruction right after here that it is up to the jury to determine the weight to be given to the confessions or admissions, and they must determine beyond a reasonable doubt,
I don't have a problem.
but definitely wait.
Yes.
It's up to the
think-
jury to determine the weight to be given any statement or any confession or admission.
I think that's a fair statement of the law, and so I don't have any objection to that.
All right, so that instruction will read as follows. Where independent evidence establishes that the victim's death was caused by the criminal agency of another, a defendant's own statements, if believed, admitting the crime need not be further corroborated by evidence connecting the defendant to that crime. It is up to the jury to determine the weight to be given any confession or admission.
That's not the statement.
Okay. Obviously over objection, but incorporating some of the defenses, that is how that, suggestions, that is how that will be given. And then the final issue we have before we dive into just going through the instructions one by one would be the argument regarding self-defense. My initial reaction when you said this was self-defense is ultimately a defense. And so all of the instructions in Runyon go to the amount, or whether they're given, goes to the amount of evidence that a defendant presents, and that a defendant argues. And I've never seen it given over the objection of the defendant.
Well, while I appreciate that, and I know Mr. Shamft has made a number of arguments to this jury, there is evidence of self-defense present, and the state is required to rebut that evidence beyond a reasonable doubt. Part of that evidence of self-defense involves him being the initial aggressor. So the jury has to know that while he may have asserted self-defense, let's say they only believe the book version, right? Or they reject everything else and only believe the book version. The book version is it was committed in self-defense, right? It's sort of like the mere presence instruction that's in here. The 2009 statement is more, I'm merely present at this particular event. Both the 2017 and the 2019 book is like Tupac shooting at us, so someone from the back seat started busting. Okay, well, Tupac would have been allowed to shoot at you. I know that there isn't a lot of evidence to support that, but the jury needs to be instructed on what the elements of self-defense are, because one of defendant's defenses, not Mr. Sham's, but defendant himself, in his own statements, his defense is self-defense. And so we're entitled to have a proper instruction of that isn't self-defense. Even if you believe what he says only in the book, that is not self-defense.
But in order for you to tie Mr. Davis into this event whatsoever, there has to be an overarching plan already at the time that the self-defense came in.
I agree. That's why legally, right? Legally, he's wrong, right? He doesn't know the law of self-defense, but a lot of defendants give confessions and statements and go, hey, it was in self-defense when they ran up on somebody with a gun and that guy pulled the gun out and shot at them and hit the woman behind them, right? I mean, that case we have right now. That defendant says, well, I committed the crime in self-defense. Well, as a matter of law, you ran up with a gun on somebody, you don't get to claim self-defense. So the jury needs to be instructed on what the law of self-defense is, because there is some evidence of self-defense in the case. Whether the defense is going with that defense or not, whether Mr. Shamft argues it was in self-defense or not, isn't relevant. The law is, if there's evidence of self-defense present, the state must disprove it beyond a reasonable doubt. And since the defendant has asserted in at least two statements that the car was acting in self-defense, the jury's entitled to know what the law of self-defense is.
Remind me, does he actually say
He says the word self-defense.
self-defense, or does he say that, we thought he was going to get to popping or something like that?
No, at one point he says...
I'm confusing it with a different statement.
At one point he says, and I can't remember if it's in 2017, I think it's in the 2017 audio recordings, where he tells Mr. Diaz, yeah, it was in self-defense. He actually uses the word. I can word search the various statements, but when I heard that, that's what caused me to go, wait a second, we need to put an instruction in here because...
Okay, so I guess I see where you're coming from now. Defense, what's your position regarding this?
First of all, I would note that if the state brings these instructions in they're adding to their burden of proof at trial, because they have then the burden of proving that the defendant did not act in self-defense. So I don't know why the state would want to add to their burden if the defense is not even requesting
Leave that on them. You don't have to worry about that
That-
anymore.
That I don't understand.
Okay.
We're not asking for those instructions because we are not going to be arguing self-defense. We believe it would be confusing to the jury. It certainly is an accurate statement of the law under Runyon, but also under Runyon, it's up to the defense to ask for those instructions. I don't know of there being any case where the state can ask for them when the defense has not, but in the end, the defense will submit that to your honor.
Okay. Final word, state?
Yeah, it's in 2017 where Mr. Diaz is, so you're saying it's in self-defense is what really happened, and Davis says, yeah.
So Mr. Diaz says it.
Well, he uses the word self-defense, but I mean, the description of what Mr. Davis is saying is, hey man, Tupac pulled out a gun and started shooting at us, and so we had to shoot back. And so Diaz is saying, so you're now saying it's in self-defense, and the defendant says, yeah.
I mean, Ms. Pandak brought up a good point. I don't know why you'd want to take on a burden of disproving something that they're not even raising, but
I mean, well, that's on me though, right?
yeah. All right, I'll give you the Runyon instructions. So we've gone through voluntariness of statement. That was granted. We're going to give instructions on that. Over state's objection, we've gone through corpus delicti. That was given over defense objection, and then self-defense is sort of, you're asking to take this on, and we're not sure why, but you want it, so we're going to give it to you. All right.
Also, for the record, I don't know if I made this record earlier, but there were wordings in the state's proposed instruction that I suggested making some additions, and the state granted that, and they made all the additions that I
Okay.
requested to other instructions, so I don't think we need to make a record as to those
Except
specific.
for she doesn't have those in front of her. I have been taking down notes of everything you said. I now have a clean copy with our instructions in order as it relates to the voluntariness. How about I save these, send them to the court, and we use those
Oh,
to
you
do
don't do
the
that in
numbers.
every other case. How come I have to do it in every other case? Anyway, okay, just kidding. All right, so at this point, I'm going to have you email all the parties with the notes that you've taken. We'll review them, and then we'll go through one by one, making sure there are no further objections. While you're doing that, any way you can make page 3?
I can't. I mean, maybe.
Yes, to
maybe
not go
Ann
more.
can get page 3 to get that word off. I couldn't
got
figure out how to
Question
get
on that. Determine whether or not the defendant is guilty of one or more of the offenses charged.
guilty. I guess
Of the offense charged? Because there's
of
only
the
one
event.
charge.
Yeah. Well, that'll solve it.
Okay.
Or just don't make it an extra.
Of the offense charged.
Or make it small.
Guilty of one or more of the.
Okay, if you do guilty of the offense charged, it actually fixes the issue.
It does.
Okay. So.
Let me
that was
save
just us
this
being
as the final.
Style wonks. All right. Send it over.
That's charged, okay.
Yeah. Before I make sure I did put those Passimo ones in here. And there's self-defense. Come on.
So the one that you sent me at 9:13 a.m.
Didn't have the self-defense ones in them, or not the. It didn't have the Passimo ones in it in place.
Okay.
So that's why I added those. Proffer agreement, statement, one statement made during police interview. Okay, yeah, they're in here. Okay, this is ready to go. I'm emailing it now.
Thank you. Do you have the Bolden instruction in there somewhere?
There is
On conspiracy?
multiple versions of Bolden in there. Do you want to send it? Do you want me to send it to Ann too?
No, I'm going to print it out myself. And you're getting rid of the sites on the Sefton and West case, obviously.
Oh, did you have sites on there? Hold on a second before I do this then. Oops.
Is there a playback in here too somewhere?
There is.
Perfect.
Okay. I think it's good now. Let's see. Go back to do instructions. Insert. Okay. I think these are all right. People check. Mike, I didn't send it to you. I sent it to Megan. I sent it to Colleen and Megan.
How dare you?
Because I know you don't even know how to open your email.
Well, I have it open, just waiting for it right now.
Oh, well, you want me to forward it to you right now?
No, I don't want to read it.
That whole law thing gets in the way of what we do.
Words.
So then just do a final run through. I'll let you read through and make sure that that's what you've agreed to, or what you've all either made a record on, and I've ultimately made a determination of misconduct. Okay.
Okay.
And then I'll number it if that accurately reflects what we have done here. Okay. So it is now my duty as judge. Any objection?
Judge, they don't have a copy.
Oh.
So, I mean, I emailed it to them, but they don't have a computer.
No.
Oh.
So can we print a couple copies? We'll just do it manually.
That would be great.
Sorry, trees. Okay. Did you get an email to you?
It's
Okay, I'm
totally
gonna forward
Colleen.
it.
You're so non-green.
It is me. I'm very old school.
I'm just gonna go print and back. It's fine. I'll be back. Thank you. You're welcome.
I'll give you a new copy of our blueprint. This is only the second trial where the voluntariness of a defendant's confession has ever been submitted to a jury.
Really?
125 trials in, only one other time have I had somebody ask for it.
I've always asked.
And in that case, the defendant did get on the stand and say they beat me with rubber hoses.
I've always included it. Thank you.
Okay. Does anyone need clips?
I would. Thank you.
I didn't bring a pen. Oh, yes, I did.
Okay.
Give one to me. Okay.
Hold on a second, guys, we gotta find a pen. We didn't plan on selling trees today.
Yeah.
One of you brought no pens, one of you brought no computer. There's something here, but, all right. I'm too tired to make the connection. Okay, let's go through then, one by one, and see if there's an objection. I will number them as we go, and then you will have a complete set, I think.
Thank you.
Okay. It is now my duty as judge. Any objection?
No.
No.
That'll be one. If in these instructions any rule, direction, or idea is repeated,
No objection.
that will be given as 2. An indictment is but a formal method of accusing.
No objection.
No objection.
That will be given as 3. A conspiracy is an agreement.
No objection.
No objection.
That will be given as 4. It is not necessary in proving a conspiracy.
No objection.
That will be given as 5. Each member of a criminal conspiracy is liable.
No objection.
That will be given as 6. If one member of a conspiracy withdraws,
No objection.
that will be 7. Evidence that a person is in the company,
No objection.
that will be given as 8. When 2 or more persons are accused of committing a crime together,
No objection.
that will be given as 9. Murder in the first degree,
No objection.
I think that should be is a specific offense crime.
Yes.
That's correct, it should be.
Okay.
Is a
Specific offense crime, not, yeah. No S on crimes.
yes.
Murder in the second degree may be a specific, a general intent crime. Okay.
And that is number,
Actually, murder in the first degree is a shouldn't it be specific intent crime?
Yes.
yeah, specific intent, not specific offense.
Offense.
A
Yes.
specific intent crime.
Yes.
And you're gonna clean these all up for the next time I use them.
All right, the next one, in this case, the defendant is
Is
accused.
that 10, Judge?
That was
That is 10.
Okay.
In this case, the defendant is accused in an indictment.
No objection.
That will be 11. Murder is the unlawful killing of a human being.
No objection.
That will be 12. Malice aforethought means the intentional doing of a wrongful act.
No objection.
No objection.
What number would that be?
13?
13? Okay. Express malice is that deliberate intention.
No objection.
No objection.
14. Murder of the first degree is murder.
No objection.
No objection.
That'll be 15. Now we're into the Byford series. The law does not undertake to measure in units of time.
No objection.
No objection.
That'll be 16. Although your verdict must be unanimous as to the charge.
No objection.
17. The next one is you are instructed if you find the state has established.
No objection.
No objection.
That will be 18. All murder which is not murder of the first degree is murder of the second degree.
No objection.
No objection. Oh, I'm sorry, no objection.
Is that 19?
That was 18.
18?
18?
Thank you.
No, that last one was 18.
Yep.
So this
Okay.
is
Also, that
19.
was, yeah, murder, which is not first.
Is second is 18.
No.
It's 19, I'm sorry.
Is 19.
All murder is 19. We on the
Great.
same page?
The killing of another person in self-defense.
So we're getting these?
Yes.
Okay. I will rely on my previous objection.
Of course. But you agree that's what we've agreed to essentially.
Yes.
All right, so that'll be 20.
These are correct statements. of the
These are
law.
all run-in. A bare fear of death, another run-in instruction will be given as 21.
Yes.
An honest but unreasonable belief in the necessity for self-defense, that will be given as 22. The right to self-defense is not available to an original aggressor, will be given as 23. Actual danger is not necessary to justify killing in self-defense, will be given as 24. The killing is justified even if developed afterwards, the person killing was mistaken, will be 25. If evidence of self-defense is present, state must prove beyond reasonable doubt defendant did not act in self-defense, will be given as 26. If a person kills another in self-defense, it must appear, will be given as 27. And then we're out of the Runyon series.
Okay.
Okay. Then we're into the deadly weapon enhancement. You're instructed if you find defendant guilty of first or second degree murder, you must also determine whether a deadly weapon was used.
No objection.
No good. 28.
That'll be 28. Deadly weapon means
No objection.
29. That's 29. State is not required to have recovered the deadly weapon.
No objection.
That will be given as 30. If more than one person commits a crime,
No objection.
that'll be given as 31 to constitute the crime charged.
No objection.
That'll be given as 32. Defendant is presumed innocent.
Can we slow down just a little bit? You're faster than my fingers.
I just wanted to make sure we took out this one word. Okay, no objection, as revised. 33.
Oh, that'll be given as 33.
Yes, sir.
You guys have met and conferred about that and come up with this.
Yes, we took out the word material pursuant to the Burnside case.
That's
Okay,
correct.
perfect. You're here to determine if defendant is guilty.
This was an instruction that the defense offered a revised version, and the state agreed. So,
So this will be given as 34 as
Thank
modified.
you.
The evidence you are to consider in this case,
no objection.
that'll be given as 36.
No, 35.
35.
35, Judge.
Thank you. That'll be 35. It is a constitutional right of the defendant. He may not be compelled to testify.
No objection.
And to be clear, you are requesting that.
Yes.
Okay, that'll be given as 36. You heard evidence regarding drug trafficking, federal convictions, and gang affiliation. This is our Tavares instruction, correct?
Correct.
Okay, that one will be given as 37.
And Your Honor, just for the record, similarly to some of the other ones, Ms. Panduct asked us to revise it a little bit, and we agreed to her revisions.
Okay, perfect. Thank you for putting that on the record. The next one is a proffer agreement is a contractual agreement between a sovereign and a defendant that obligates the sovereign and the defendant to its terms.
Your Honor, we discussed this. My concern was with the word sovereign, that the jury may not understand that. And so there was some discussion about changing that word to jurisdiction or government. But
How about a specific government entity? Is that better, or? But I mean,
I don't know if the court has a similar concern.
Sovereign always reminds me of a sovereign citizen. Which
I know.
You can use whatever term, like a specific government entity.
Okay,
I think that would be better.
all right. So if you guys want to replace the word sovereign with specific government entity, it does. So it would read: a proffer agreement is a contractual agreement between a specific government and governmental entity and a defendant that obligates that government entity and that defendant to its terms, wherein both sides of the contract expect the benefit in exchange for entering into the contract. It does not bind any other government entity. In this case, you have heard that the defendant entered through. Do you want to spell out counts through?
Oh, yes. It should be spelled.
Instead of like a drive-through at McDonald's, like the actual way the word is spelled, guys. All right. Through counsel into an agreement with the United States government. The state of Nevada is not bound by that agreement. So there's no objection to that with the replacement of the word sovereign.
Yes,
Okay.
that is.
I'll give that one as 38. A statement need not made by the defendant himself to be considered his own statement.
No objection.
That will be 39. Statements defendant made during a police interview. That is,
Okay.
This is going to be 40. We have discussed it. Your prior objections stand, but ultimately your request for instructions on voluntariness are acknowledged and given.
Thank you.
All right, and then the next one,
Just for the record, the state does.
and the state
objects
objects to
to
the
the
giving
vote.
of them, but got their wording.
Correct.
Okay. So that was given as 40. And then the next one is in the same vein, in making a decision about the voluntariness of a confession or admission. This will be given as 41 pursuant to our previous argument. The next one is where independent evidence establishes.
Let me read this more carefully.
This is the corpus one. We called it corpus, but I disagree. It's really corpus.
about the corroboration one.
Corroboration instruction, let's call it that.
Our objection stands.
Okay, but you agree that's what we
That's the
decided
wording
on?
that the court decided on.
Okay, so that will be given as 42. Previous objections are noted. The next one, wherever there's slight evidence that a conspiracy existed.
Okay, I usually put this one earlier, but let's just keep it where it is. Okay, 40, no objection.
That'll be 43. In deciding the facts, you may have to decide which testimony to believe.
No objection.
This will be given as instruction 44. A witness who has special knowledge, skill, experience, training, or education in a particular assigned profession or occupation as an expert witness.
No objection.
That will be given as 45.
Wait, hold on.
Although you are to consider
Admit them.
only the evidence in reaching a verdict, you must bring your common sense.
No objection.
That will be given as 46. During this trial, you received certain audio recordings.
No
And
objection.
It explains that the audio recordings are the evidence as opposed to the transcriptions, which may contain errors.
No objection.
That'll be 47. The next one is you may not discuss punishment.
This is one that I asked for alternative language to be used, and the state agreed.
Okay, so as modified, it will be given as 48. When you retire, you must select a foreperson.
No objection.
That will be 49. In your deliberation, you desire to be further informed on any point of law.
Objection.
This is the playback, so
Hold on. So 50, no objection. And then 51.
we need the instruction in there that the jury is not to test any theory of the case, etc.
Yeah, we should.
Oh, yeah, I always forget that now. There's a court rule for that. So maybe we should add that before 51,
Okay, let me pull up.
or make it 51.
Let me pull up the ones that I've used for previous cases.
Wait a minute. Hold on.
Oh, okay. I'm realizing at this point that we're missing ones.
I feel like we're missing one too.
We are, and she's grabbing it. It's the one where they're not supposed to do any research or look on social media and all the other stuff that the court requires us to do.
And I haven't finished with going through them, but I realized at that point that we were missing that one. The Bowman instruction.
Which is going to be 51. I'll add it as a change. Page break. I think the court typed that one for me in our last trial. Let's see, Aubrey. I have to bring up bad
Please
news.
don't mention that right now.
Using that one.
Oh, those instructions work great.
Yeah, where is that one?
Ask him. Hey, you guys, do you guys have the credibility instruction in there?
Yeah.
Yeah, it's the lengthy one. It's not the short one.
All right, so the
Okay,
Bowman
we wanted the
instruction
short
needs
one
to be
again.
given, which states, during deliberations, other than deliberating with each other in the deliberation room, jurors are not to communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. Read, watch, or listen to any news or media accounts or commentary on the case. Do any research such as consulting dictionaries, using the internet, or using reference materials. Make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own. Any objection to that wording of the Bowman instruction? I think
Which
that's
instruction is this?
it's the instruction from.
Which number though?
I'm
It will
going to
be
have to add it
51.
in. We don't have it. It's from Bowman versus State. In 2016, the Nevada Supreme Court indicated it was. First of all, that I had to read the admonition that I do every single time they leave the
Could you
room.
restate it? I just noticed a
Absolutely,
missing
yes.
instruction that I thought was in there.
Okay. During deliberations, other than deliberating with each other in the deliberation room, jurors are not to, 1, communicate with anyone in any way regarding the case or its merits, either by phone, email, text, internet, or other means. 2, read, watch, or listen to any news or media accounts or commentary about the case. 3, do any research, such as consulting dictionaries, using the internet, or using reference materials. 4, make any investigation, test the theory of the case, recreate any aspect of the case, or in any other way investigate or learn about the case on their own.
No objection.
Okay.
And what number? That's
We can just make it 51.
And then I'm emailing it to you, Mr. DiGiacomo.
Oh, I just, the beginning of the one we used last time was slightly different, so it's during deliberations. Just review that, and I have it in here already.
During deliberations, other than deliberating with each other in the deliberation room, Jurors.
Deliberating
with each other
other
in the
deliberation
room,
comma,
jurors are not to, colon.
or not to.
do
Okay.
all the things. Okay, so that'll be 51? Is that the idea?
And then the
That would
last
make
one will be
sense.
52.
Yes, so we'll put the Bowman instruction as 51, and then 52 will be, now you will listen to the arguments of counsel who will endeavor to aid you to reach a proper verdict.
I just,
And that would be 52.
there was an instruction that was omitted from these, so the state presented a different credibility instruction.
Okay.
But I thought that this one, which is a stock instruction, would be included, and I see now that it is not. It's the credibility or believability of a witness should be determined by his manner upon the stand, his relationship to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weakness of his recollections. If you believe that a witness has lied about any material fact in this case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. That is a stock instruction.
Any objection to using that instruction as opposed to the one that you've included? It's
At 44, if you want to replace that in 44, I have no objection to
Okay.
that.
And I also don't mind using both of them.
Well, I mean,
We
there's
need one.
duplicative. We need one. So,
So
if you want to use,
if that's your request for that instruction, Ms. Pandak, that's the one we'll use.
Thank you.
If you want to just give that wording to Mr. DiGiacomo. Or he has
I
to
actually
type it
can
up.
get it
Can you
because
get it?
what
The
happens?
one he's used
What
in
happens
every,
is the court.
he's used that in every other trial and objected to this one, but today he decided to switch it up on me, so
Yes,
I'm glad I saw it.
you're fine. Okay.
just because I stole these instructions from ones you made me do last time, so I'm like, I'm not even going to fight this time. The ability of a witness should be determined by his manner upon the stand. His
Okay, so while he's working on that, the state has proposed the verdict instruction, so the verdict form, so I assume they have no objection to it. Ms. Pandak, any objection to the form of verdict?
Mr. Samt had requested that not guilty be listed first. I told Mr. Giacomo I did not agree.
We object.
In general, in most cases, I have no objection to doing it that way, but because of the way that the step-down instruction works, it makes sense in homicides to have it in this order. And so I understand the objection and I understand why it's been upheld multiple times going in the descending order. Essentially, it converts the step-down instruction to a step-up instruction, and so that's generally why I don't do it in these cases. But, all right, so other than that objection, the crimes included are the crimes you're requesting to be included.
Yes, we did not request a voluntary manslaughter to be included.
Okay. That's on record. All right, Mr. DiGiacomo, then do you have everything added to yours?
I'm still typing that, Judge.
Okay, perfect.
But as soon as I do, I will send it to you. Material. The case made regarding entire test of that witness or any portion of his test which is not proved by others. Okay, I think save as, final numbered, and I can send this around to everybody.
Okay, sounds good. Anything else we need to address while we have this time before we do closings on Monday?
We'll be at 9 o'clock as opposed to 9:30?
We hope.
I think the idea is we're having everyone get here at 9, but if we ultimately start a little later, that may be what ends up happening. But I also have to read instructions, which takes about well, with 52 instructions, we're thinking maybe 20 to 30 minutes. So I don't think that we would be starting actual argument until about 9:30, at least. Mr. Sam?
I'm sorry, Judge. I don't remember in this department. Do you give each one of them a copy of the instructions to follow along with?
So what I do is I read the instructions to them and tell them to write down the ones that they want, and then we give 6 copies in the back.
I see. All right.
Okay?
Thank you.
Anything else?
Nothing from the state, Your Honor.
Nothing from defense?
No, Your Honor.
All right, we'll be in recess. We'll see everyone back on Monday for closing arguments. Thank you, everyone. Have a good weekend.
Thank you.
You can have this back.